I'm talking with Attorney General Tim Fox. Tim, an important Supreme Court decision that came down today. What can you tell us?
Well, Peter, 28 states, including Montana, filed suit against the EPA's carbon regulations that they call the Clean Power Plan some time ago. And we are in the D.C. Circuit Court of Appeals. That court denied a request for an injunction or a stay against the regulations pending the outcome of the merits of the case. We appealed, the 28 states appealed that decision. We applied for a writ of certiorari to the United States Supreme Court in a fairly extraordinary move to try to get the Supreme Court to issue a stay of the regulations. And we argued in the court that they ought to do that because there's a reasonable possibility that more than 4 of the justices would agree with us that we have a meritorious case, and that there's a likelihood of irreparable harm that would result from a denial of a stay. And fortunately, a majority of the court agreed with us and issued that stay today. So the EPA cannot implement their carbon regulations pending the outcome of the case in the D.C. Circuit Court of Appeals. That court has ordered an expedited briefing schedule and hearing. The hearing will be in the first week of June. We expect then a decision later this year. I think one of the more important outcomes here is that it questions now whether or not the EPA can require the states to submit state implementation plans under these regulations by a September 2016 deadline. That deadline probably is out the door. We're still analyzing the case, and that would be huge for the states, including Montana, because we wouldn't have to waste time and energy and resources putting together a state implementation plan until after the case is finally decided, which I would anticipate now won't be fully and finally decided at the United States Supreme Court level on the merits until possibly next year. So it's a big win for the states, but the case goes on, and we'll have to continue to litigate the merits.